Good afternoon. I'm Julia Coakley. On behalf of the MGAA, I'd like to welcome you to our briefing this afternoon, which is being delivered by Brown Jacobson. Before handing over to our presenters, I'd like to cover a few housekeeping points. Do make sure that you have your microphone and camera off. And if you'd like to ask a question, please use the chat button at the bottom of your screen. These will be answered during the Q&A session, but if we do run out of time and your question isn't answered, please do make your contact details known and we will get back to you post-event. The MGAA's Programme of Learning and Insights has been accredited by the Chartered Insurance Institute for the quality of content and supporting materials, with CPD hours applicable if relevant to your ongoing professional development. The recording of this briefing will be available on our website and MGAA YouTube channel, with the PowerPoint presentation to follow post-event. Finally, you will be sent a feedback survey. Please do take time to complete this, which should take no more than 2 minutes of your time, and it does allow the MGAA team to deliver the best quality events for our members. So today's briefing, Modern Slavery and the Supply Chain, Insurance Market Risks, is being delivered by Jeremy Irvin, Partner and Head of Financial Services Regulation, Raymond Silverstein, Partner and Head of Employment, London, and Helen Sim, Partner, Financial Services Regulation and Financial Crime. Jeremy is a governance expert in insurance markets with a focus on FCA consumer duty, operational resilience, and ESG board effectiveness. He led the regulatory aspect of transforming EDI practices in UK insurance study and has extensive experience in regulatory supervision, notifications, whistleblowing and enforcement. Raymond leads the Employment and Business Immigration team in London, advising clients on modern slavery statements. With over 20 years' experience, he specialises in employment issues across recruitment to dismissal, particularly in financial services and insurance. Raymond also led the employment law aspect of the Transforming EDI Practices in UK Insurance study. Helen specialises in financial services regulation and financial crime. She represents corporates and individuals in regulatory investigations and enforcement, advises on compliance and financial crime requirements, and has expertise in policy development, internal investigations and training delivery. So, Ray, I think it's over to you first.
Thank you very much, Julia. And good afternoon, everybody, from Bevis Marks in the heart of the Square Mile. Thank you for joining. This market briefing addresses a number of themes for MGAs in managing their legal and regulatory risk. The points we'll be exploring are very much at the cutting edge of the thinking on the juncture of 3 key issues. The first issue is, in broad terms, ESG, and the increasing scrutiny which regulators and commercial parties are applying to the crime of modern slavery. I will be speaking about that aspect. Another issue is anti-financial crime and anti-money laundering, and how criminality that may take place outside the UK, including modern slavery, has become a factor in risk management in these key areas. Helen will be speaking about this. A third issue is how the consequences of anti-financial crime and money laundering law affect the enforceability of policies which MGAs deal with, and also affect risk management policies and procedures. And Jeremy will be covering that. And just to add that the context of this presentation is a recent landmark decision of the Court of Appeal that has changed the risk factors to be aware of. I think Julia has told you all about us, so we don't need to worry about that. And here's just an overview of today's session. And that landmark case is the Uyghur case that's referred to on this slide. And here are the learning objectives, which, as Julia mentioned, are important from a CPD perspective. And to understand this landmark decision and how it needs to be factored in to your risk taking processes to take a risk-based approach. So modern slavery, and what is it? The Modern Slavery Act defines modern slavery as being the offence, it's a criminal offence of slavery, servitude, and forced or compulsory labour. And the forced labour aspect of that will come through a bit later on. But modern slavery also encapsulates the offence of human trafficking. And it's worth noting that that offence is committed regardless of whether or not the individual knows or in fact is asked to be trafficked. That makes no difference to the criminality of the offence of human trafficking. Sadly, modern slavery is a growing global phenomenon. These figures, I'll mention them in a second, are consensus figures that have been pulled together by various agencies that work in this area. And it's true to say that there are more modern slaves globally in the world now than at any time in history. And I think that is almost certainly mostly due to the number of conflicts that are going on around the world and have been for some time. That seems to be the main driver for modern slavery issues. In the UK, it is estimated that there are approximately 100,000 modern slaves in the UK. That includes children, incredibly. And in fact, a large percentage of those slaves are UK citizens. They are not from outside, which I think will come as a surprise to some. Worldwide, it is estimated there are approximately 50 million people in modern slavery, which includes forced marriages, which has significantly increased since 2016. And just to put this into a little bit of context, all of those figures translate to 1 in every 150 people on the planet being a modern slave. So this is a very serious issue for everybody. The case that we will talk about a little bit this afternoon is the King on the application of the World Uyghur Congress against the National Crime Agency, which was a Court of Appeal decision of this year. And it was brought by an organization that promotes the interests of the Uyghur people living in the Xinjiang Uyghur Autonomous Region in China, which is a vast part of China. And it was brought because the National Crime Agency, which, as you may know, is the UK equivalent of the FBI, refused to investigate alleged offences under the Proceeds of Crime Act or commence a civil recovery investigation regarding Chinese cotton products that were brought into the UK. Chinese cotton products clearly covers a vast variety of all sorts of products. So the World Uyghur Congress applied to the Court of Appeal to challenge the decision of the National Crime Agency. And at the Court of Appeal, there was unchallenged and agreed evidence that 85% of cotton grown in China comes from the Xinjiang region, and that there is a growing and substantial body of evidence that forced labour, which is largely from prisons, accounts for a significant proportion of all cotton originating from China. So it's not difficult to see perhaps why the Uyghur Congress was saying it's not difficult to join the dots between the risk of cotton being imported or cotton products being imported from China actually being the product of forced labour. And that was what this case was all about. Over to Helen.
Thanks very much, Ray. And thank you everyone for joining us today. So yeah, I'm going to now dive a little bit deeper into UK money laundering regulation and just consider the impact of the case that Ray's talking about on future considerations. As Ray has already mentioned, the essence of the complaint of the WUC was that the NCA had refused to investigate alleged money laundering. Now, because it's a criminal offence, in the UK to deal in prison-made goods, the WC's view was that the sale and distribution of goods from locations where effectively forced labour is prevalent presents a clear money laundering risk. So the JR and the appeal challenged the NCA's decision not to launch an investigation. And the NCA's decision, or the aspects of the NCA's decision that was challenged, was first of all, the NCA said it's necessary before we investigate alleged money laundering for us to be able to identify a specific product as criminal property. And secondly, and this is the bit that we're going to really delve into today, the NCA's position in refusing to investigate was that effectively, if within a supply chain, somebody has paid adequate consideration, and we'll talk about that, what that means in due course, but if someone's paid fair value for the goods that they buy, then this has the effect effectively of cleansing criminal property, meaning that others further down the supply chain can safely purchase those products without committing money laundering offences. Now, that was definitely the view prior to this case. Everybody seemed to believe that the only sensible reading of the Proceeds of Crime Act was that effectively, if fair payment is given for what is criminal property at any point in time, then at the time that fair payment is made and after that, there can be no money laundering offences committed. In other words, the payment of adequate consideration, a term that we'll come on to shortly, cleanses that property. Now, that isn't something that's just a practitioner-held view or something that people who were looking to put perhaps a positive spin on the situation held. I was having a look at guidance, and actually the Bar Council's guidance given to barristers as early as January 2024 and approved by the government via HM Treasury stated that in cases where adequate consideration has been provided, the funds in the possession of the recipient are no longer the proceeds of crime, regardless of whether that person knows or suspected that they are the proceeds of crime or not. So that was effectively the way that the NCA understood the position to be. And looking at the situation in hand, okay, somebody may have purchased the cotton from a situation where they thought, or at least they suspected, it may have emanated from slave labour, but as long as they pay a fair value for it, then everybody who buys it further down the chain or has involvement with that consignment is okay because of this adequate consideration defence. The NCA's view was that the particular consignment talked about that effectively somebody has paid fair value somewhere in that supply chain, meaning that it can't be criminal property and the chances of money laundering are low. Now, what the Court of Appeal judgment has now made very, very clear is that even where a fair price has been paid at a certain point of the supply chain, others beyond that point may commit money laundering offences if they either know or suspect that they're dealing with criminal property. Now, that really has transformed the landscape for supply chains and has meant that those within them are more at risk of committing money laundering offences than they were before. This all seems to be very much part of an ongoing trend of holding companies to account and looking beneath the corporate veil. We only really need to think about recent changes under the Economic Crime and Corporate Transparency Act, and particularly something that I'm very keen on, the offence of failure to prevent fraud, which is the third so-called corporate offence, which will come into force 1st of September next year. So really the direction of travel for UK business is very much one in which that business is expected to be hyper vigilant about financial crime and do its bit to stamp it out. Okay, I'll just talk now for a few minutes on money laundering itself. I've put the 3 substantive money laundering offences up on the slide. Money laundering is defined in POCA as the process by which the proceeds of crime are converted into assets which appear to have a legitimate origin, so they can be retained permanently or recycled into further criminal enterprises. As the case we've been discussing makes clear, that criminal conduct doesn't have to happen in the UK for a UK money laundering offence to take place. Subject to a very, very narrow carve-out, if conduct is lawful in an overseas jurisdiction but would be unlawful in the UK, then the proceeds of that conduct can become criminal property here. So the key offences are captured on the slide. Section 327 is probably what we would think of as the traditional money laundering offence, so disguising the nature, the source, or the location of criminal property. Section 328 is probably most likely to capture those in the financial services industry who undertake transactions on behalf of third parties. So to establish an offence, a prosecutor needs to show that a person, entered into or became concerned in an arrangement which he or she knew or suspected would make it easier for someone else to acquire or retain criminal property, but also that that person knew or suspected that the property was benefit from criminal conduct. Now, this reference to knew or suspected is very, very important, and we'll come back to that in due course. Finally, Section 329 is the acquisition of criminal property, and that offence is only committed where a person either knows or suspects that the property they acquired constitutes or represents his or another person's benefit from criminal conduct. As you can see there, the maximum penalty, 14 years imprisonment or an unlimited fine. So yeah, moving on now to reporting, and consistent with the theme of expecting companies to be at the forefront of the fight against financial crime, POCA sets out positive obligations to report suspicion of money laundering, and the failure to do so is a criminal offence. Now, I appreciate that most, if not all of us in the room, are not in the regulated sector for money laundering purposes, but actually these obligations can also bite on non-regulated organisations wherever those organisations have nominated an officer to whom internal money laundering suspicions ought to be reported. So in the non-regulated sector, if such a person received a money laundering report in the appropriate way through the internal channels, then provided those points in the left-hand box of the screen are made out, then that person commits an offence unless their suspicions are reported to the NCA in the appropriate way as soon as possible. Now, you'll note that the right-hand box refers to the regulated sector, and in the regulated sector, employees are also individually subject to their own obligations to report money laundering suspicions internally, where they have them, to the nominated officer. Now, I'm drawing attention to that today, partly for completeness, but also because I think it's important really for us to acknowledge that legal obligations or best practice in the regulated sector may actually lead to higher expectations elsewhere. So even though many FCA regulated businesses aren't subject to money laundering regulations 2017, the FCA may well expect good conduct to include money laundering vigilance to the same standard. Okay, suspicion. So coming back to first principles, it's really important to bear in mind that the Section 328 and 329 offences can only be committed where there is knowledge or suspicion of money laundering on the part of the person who's engaged in the transaction. So what is suspicion? Well, you might be surprised to learn that despite its significance, suspicion isn't actually defined anywhere within the proceeds of crime legislation, nor within the recommendations of the Financial Action Task Force or any of the EU money laundering directives. So instead, we have a situation where really it's left open to the court to interpret and define the concept. Even as I have done looking in the dictionary doesn't necessarily help us, because different dictionaries will give us slightly different definitions. Suspicion probably doesn't even describe a singular state of mind. It could cover an inkling, it could cover believing something is highly probable, or it could cover believing something is true. So because of that, many judges over the years have grappled with the question, and there have been lots and lots of cases, many of which make interesting reading for people who are interested in financial crime like myself. The leading case, which I've put up on the slide, is the Crown against De Silva, and in that case, it was decided that the essential element to constitute suspicion would be a suspicion, just looking back to the slide, the person who suspects must think that there is a possibility which is more than fanciful that the relevant facts exist. So a vague feeling of unease, feeling uncomfortable about something, in other words, does not suffice. But the statute, in other words, POCA, does not require the suspicion to be clear or firmly grounded and targeted on specific facts or based on reasonable grounds. So I think from that case, we can take it that it is quite a low threshold and it's pretty subjective. So whilst a suspicion has got to be genuinely held, it doesn't have to be reasonably held. So the courts haven't introduced a reasonable test or a threshold. The statement, I think, that it has to be more than fanciful shows that there is at least some basis in fact that you need to have in order for suspicion to be made out. It's just a very difficult concept to define, and that's why when people are deciding whether or not they have suspicion, there are often quite complicated considerations to be brought into bear. So we talked earlier about the concept of adequate consideration, and I was explaining that before the Uyghur case, it was widely believed that payment of adequate consideration at some point in a supply chain would effectively cleanse property and turn it from criminal property into something that could safely be traded beyond and into other supply chains without fear of money laundering offences arising. So within the legislation, Section 329, the defence of adequate consideration, only applies to the possession of criminal property under Section 329. The effect of the Court of Appeal decision now is that everybody is now having to think about the narrower application or the narrower understanding of the application of this to property and its impact on supply chains. What the Court of Appeal in the Uyghur case said that the exemption affords protection to the purchaser while he has the property in his possession, even if he knows it's criminal property, but would not protect him if, for example, in that knowledge, he transferred it to someone else or took it out of the country and thereby became potentially liable for other substantive money laundering offences. So I think if you think about the Uyghur case, what that really means is that the person at the very, very end of a supply chain, the person who bought the T-shirt and wore it, has a protection here because they are possessing, if they are suspicious, and if it's criminal property, possessing criminal property. But if those same factors apply to people higher up in the supply chain, then there is at least a risk that the defence wouldn't apply and money laundering offences may have been committed. So I think this presents a real concern for organisations who particularly are thinking about entering into contractual relationships or entering into supply chains with organisations in locations where there is a concern, a bit like in the case we're talking about, of widespread forced labour or widespread environmental crime, and there is a genuinely held suspicion that what could be passing through their hands is criminal property. So what can organisations do if they would like to enter into those transactions, but based on the test that we've talked about, have suspicion that criminal property could be involved? Well, the making of a suspicious activity report or a SAR to the NCA in advance of a transaction may assist here. So the SAR process works in two ways, really. First of all, it's the mechanism through which the legally required disclosures that we talked about earlier are made. So in other words, somebody in the regulated sector or a nominated officer outside the regulated sector will report suspicions about money laundering being carried on by others through this channel. However, persons in the regulated and non-regulated sector can also use SARs to seek a defence to money laundering for future acts, and those are called DAML SARs. So the process of seeking a DAML SAR cannot be used to bless previous actions, so you can't use it to rectify something that's already happened, but it can be used as a way prior to the receipt of or dealings with criminal property or suspected criminal property to obtain a defence for the act that it is that you would like to do. So I've advised a number of non-regulated organisations about this at various different stages of commercial transactions and also during due diligence on acquisitions. Only very recently, Jeremy and I had to consider whether pre-acquisition regulatory difficulties meant that our client, the purchaser, would be required to submit a pre-completion SAR to obtain a defence for potential money laundering offences in the buying and running of a business. So the process I've set out on this slide, you put your SAR in via the specific channel. You have to register with SARS online to do so. once you've made your SAR and you are therefore, you are setting out really what the suspected criminal property is, what it is that you would like to do with it. The NCA then has 7 days to consider the request, known as the notice period. It's 7 working days actually. So if consent is given within that time, then if you stick to the act that you've sought a defence for, then you will have a defence to money laundering in the future, should it turn out that you actually did in fact deal with criminal property. If no response is received in that time, then it's known as deemed consent. So once again, after the 7 days has expired, then you have a defence if you proceed. Now, I have to say, I haven't acted in many cases where the NCA has refused consent, but they can actually do that if they would like more time to investigate the matters that have been reported to them. So during the time that the NCA is investigating, nothing can happen. They'll call it the moratorium period, and that will last up to 31 calendar days, or it can be extended up to 6 months maximum through order of the court. Now, I did refer in that slide to tipping off. That's only something that can be committed in the regulated sector, but it's really important for those outside the regulated sector to make sure that when a SAR has been submitted, no steps are taken that could prejudice an investigation, because doing that is also an offence of itself. Always sensible to keep any SAR confidential and not to tell anybody about that other than the limited circle of people internally, certainly not to tell anybody who is the subject of the SAR at that stage and perhaps further down the line. So thinking about some practical implications and considerations, it's definitely fair to say that the judgment has sent absolute shockwaves throughout all industries, including the legal industry in which I belong, and its full impact has definitely yet to be seen. So as Jeremy's going to talk about in some more detail when I hand over in a second, there's certainly a likelihood, we believe, that there will be further action from other NGOs in other hotspots where illegal activity is suspected to be taking place on a wider scale. I've referred on this slide to illegal logging, but there are plenty more that Jeremy will talk about and that we can bring to mind. I think what organisations need to be grappling with now is the extent to which, if they are genuinely suspicious that criminal property may be present in supply chains, what they do about that, and whether or not they can have such a suspicion based on pure geography or pure industry rather than specific evidence in front of them. So what can organisations do? And at the moment, it's quite a difficult time. People are very much reflecting on their position, but thinking about suspicion, it's very important to bear in mind its subjective nature. So commission of a substantive money laundering offence requires knowledge or suspicion that the property in question is criminal, and it also requires that property to subsequently turn out to be criminal. So establishing liability is dependent on an enforcement body being able to establish that either the company or the individual within the company had the requisite state of mind. I mean, I think a perverse impact of that really, and especially in the light of the increasing obligations on financial and other institutions that I've been talking about to conduct due diligence, it's almost got the potential to absolve companies who fail to undertake proper due diligence, and can almost create a situation where you might be inclined to think that ignorance is bliss. Now, I think most organisations, and especially all of us who are regulated by the FCA, will find that regulatory requirements or sensible risk management completely precludes that approach. But what some organisations may find, therefore, is that they're unwilling to enter into contract or receive monies from people in certain industries or locations without conducting widespread due diligence wider than before, or perhaps even reporting the matter to the NCA via a DAML SAR to get the ultimate protection going forward. So in many industries, including my own, guidance is keenly awaited on the impact that this is going to have on day-to-day business. Thank you for listening. I'll hand over to Jeremy now.
Thanks, Helen, and good afternoon, everybody. And I hope you're appreciating our commitment to transparency by sharing our working version of the slides rather than the presentation version, but such is the magic of IT at any given moment. So a quick reminder what we're talking about here in the background to this decision. And this section of the presentation is going to be very much around unpacking the key factors that went into the decision that was ultimately made in the World Uyghur Congress case. So this gives an idea of the sheer scale of the autonomous region in issue and how significant it is for cotton production for China and internationally. So the starting point for any MGA when they're thinking about anti-financial crime and anti-money laundering issues is the fairly high-level sets of rules and guidance that you can find in particular at CISC 3.2.6 and 6.3. And to distill those down very briefly, it all comes down to having effective systems and controls to identify, assess, monitor and manage money laundering risk. These systems and controls have to be comprehensive, but also proportionate. And there's an interesting tension, I think, in the way that rule has been drafted. But one of the things which is important to draw out is the public policy element behind the rules and the FCA's requirement that, in effect, firms do their bit for society by not allowing themselves to be vehicles or agents for the risk of crime and terrorism. And this public policy point is something that I'll be coming back to. When you're thinking about comprehensiveness and in particular thinking about proportionality, it's important that an MGA takes into account the way its business works, its business model, what risks are made up within its book. Its customer profile is particularly important, but also its distributor profile and other relationships will be particularly important. Training is essential and effective systems and controls around internal monitoring and reporting and documenting of policies, procedures and relevant outcomes. Now, all of this may be very familiar to those attending today's presentation and in a lot of ways is simply common sense. But where the Uyghur Congress decision comes in is that it really poses some significant challenges to these concepts of comprehensiveness and proportionality, and some significant challenges about what it would really mean to run an effective anti-money laundering and anti-financial crime risk management program. So again, just focusing on the specifics of the case in Uyghur Congress, cotton is a really interesting crop. It involves very large volumes of water to sustain it. It's heavily industrialized agricultural production process. We're looking at lots of pesticides, etc. It involves a number of industrial stages for processing. And it also gives rise to derivatives trading. So that it has a number of spin-off, no pun intended, aspects, any of which may involve insurance policies being written around them, around relevant risks. So this could extend to some sort of all risks policy, transportation risks, shipping, railway, vans, lorries, deliveries, factories, and so forth. And all of the risks that are associated with those, including obviously D&O in respect of senior manager exposures. Again, thinking about the regulatory rules around anti-financial crime and anti-money laundering, it's important to consider how the sorts of factors at issue in the Uyghur Congress case result in very particular outcomes under insurance law, the law governing insurance policies. And this is a good example of a general proposition that insurance is often a very special case because managing regulatory risk exposures requires careful management of legal risk exposures. And this slide summarizes the key propositions around the legal risk exposures that would arise from an insurance contract that the subject matter of which involves or is some form of illegality, for instance, criminal property or property which may be regarded as having been tainted by illegality. And there are two different outcomes which arise when you have insurance of an illegal, what might be called an illegal subject matter. Either the contract as a whole might be void, or the claim, the policy is not void, but the claim can be denied. Now, from an MGA's perspective, it's obviously highly unattractive to be underwriting policies which are going to be found to be void by a court, because that would obviously involve an unwinding of the entire placement and business process around that void contract. So while having an enforceable and valid policy, which results in a denied or deniable claim for illegality, is less unattractive than having a void contract and an enforceable contract, that still presents potential problems for an MGA because of customer treatment, fair treatment, and product governance rules. So although moving forward in this presentation, I'm going to be focusing around these issues of the unenforceability, the invalidity of contracts, it's worth thinking about the regulatory and compliance risks that could arise from policies which are written but are found, but where the MGA or the insurer would look to run the defence that the claim is not payable because of the illegal subject matter. That is indeed an entirely separate seminar on its own right, and we can return to that in due course. But for today's purposes, I'm just going to focus on the void contract point. So when does an insurance policy, when is it, would it be regarded as void by a court? So the first point is around express or implied statutory prohibition. I.e., is there a statute like Proceeds of Crime Act which says explicitly or implicitly, and this is where it does get complicated, that that sort of insurance cannot be written. Secondly, the proposition is where the insurance contemplates conduct which is prohibited by law. That's to an extent is a way of a sort of restatement of the first proposition, but again comes to this point about explicit and implicit purposes of relevant legislation. And then the final point is where the policy might have been perfectly good as a matter of law at the start of its inception, but actually the way that the insured has used the contract or dealt with the contract or responded to the contract has led it to conduct which means that public policy would not allow the insurance to stand as a whole. And again, this is where the public policy point kicks in that I mentioned earlier, which is thinking about the public policy purpose of Proceeds of Crime Act and similar anti-money laundering and anti-financial crime legislation. So condensing those three propositions that I talked about earlier, which is either the contract itself is illegal at the stage of formation or becomes illegal as a matter through the conduct of the insured, there are some perhaps slightly more easy points we can knock off at the start. So some legislation obviously specifically explicitly addresses things that are banned, and that would have typically come up in times of war and anti-terrorism legislation. Where it gets challenging is where there is no such explicit ban, but we have to construe, or the court has to construe the contract and the relevant legislation. The leading case on this is this St. John Shipping Corporation from 1957. So you can see this is not an issue which arises frequently as a matter of insurance law. And that case put forward various tests as to how a court should consider whether a particular insurance policy should be allowed to stand, but maybe the claim not allowed, or whether policy can't be allowed to stand at all. A useful example given in that case is the concept of a collateral contract, which is, for instance, for a vehicle which is perhaps might have been driven or is intended to be driven by way of illegal taxi service, so without the relevant license. Nevertheless, a contract which deals with its garaging it or repairing it, or the insurance of it while it's in the garage or being repaired, would not be void and unenforceable and could be claimed upon. There's a very difficult piece within St. John about this concept of trying to test the meaning of a statute by construing the contract in the abstract, almost in a void. That's probably not the most helpful way to think about the issues in the case of Uyghur Congress. A better probably test, which a court is more likely to think about, is the dicta here in the Beresford case from an even earlier case of 1938, which basically is, but for the crime, in this case it was a suicide, there would not be the relevant subject matter against which a claim could be brought, in respect of which a claim could be brought. Now that's really important concept when you're thinking about, in the Uyghur Congress context, that in effect the entirety of the cotton production being unlawful and being based on modern slavery and therefore unlawful. So there is a good argument to say that insurance around the cotton coming out of the Xinjiang autonomous region is inherently tainted from the very start, and therefore there could be a good argument that could be run that no insurance in respect of that crop and potentially even forms of its worked product at various stages of its industrial life cycle are capable of standing if challenged. Now, how did the court get to that state, get into a position where it was able to say it accepted that there was this wide-scale endemic criminality going on in the production of cotton from China? Well, interestingly, this was not done in the classical way of direct witness evidence or even expert evidence. It was drawn from international publications which were regarded as sufficiently credible, and in particular work by NGOs reporting on the state of affairs within Xinjiang. Now that in turn raises some very interesting questions about how far those concepts could go. So there are sources of information, publicly available information, which indicate where certain territories, certain jurisdictions have endemic criminality problems. And it is very easily arguable that places which exist on the UK sanctions list, particularly where there are multiple entities subject to UK sanctions, would be the sort of place which could give rise to a taint of criminality to the subject matter of any export coming out of that jurisdiction. And that's quite a lengthy list, as you can see, with most of the classical examples we would expect, and in many ways is quite a sort of common sense situation. However, there are many NGO and reporting organizations, media organizations, who have regularly report on the state of criminal activity and the state of various issues in multiple jurisdictions. And I've just highlighted one here, which is called the Organized Crime Index. And that has various different ways of measuring the level of risk of criminality, and in particular organized crime going on. Its permeation of the body politic and of society and the economy. And there are some really quite interesting entries based on the particular methodologies used by that particular NGO, that particular publication, which bring out some very interesting countries. Major players such as Brazil and the Central and some South American countries you can see there. Interestingly, Italy, an EU, First World, D7, etc., nation was listed by this organization, as indeed was Turkey, and similarly Jamaica and the Philippines. Now, this really takes us to a couple of key issues here, which are growing features of modern litigation and litigation around ESG, put in its broadest terms. And a key feature here is the role of the NGO and the increasing power of NGOs, and how well resourced they are, and how they are able to develop material and promote and publicize material, which in the case of Uyghur Congress was accepted by the court. To an extent, it was readily accepted by the parties, but it was certainly accepted by the court. And this is going to be worth thinking about if NGOs, for instance, start to target insurance, the insurance market, insurers and others, MGAs perhaps, who are involved with the insurance of products which are associated with or coming out of jurisdictions or even passing through jurisdictions which have high levels of criminality, as may be alleged. So we may be at the start of really quite an important risk factor here. And this risk factor is very much about reputational risk. When we're coming to thinking about the FCA's expectations on MGAs for risk management, reputational risk of insureds for their own account, but more importantly for the jurisdictions in which they operate and from which they obtain their subject matter materials to be insured, is going to be a key factor in the underwriting risk for the validity of the policy, and also for the anti-financial crime risk management systems and controls. So that was a lightning tour through this very complex, dense area. Here are the learning objectives again. Hopefully we've been able to highlight something around, in particular on that fourth piece, the taking a risk-based approach, and how that is still at its very early stages given this judgment. As I said at the start, this is very much at the cutting edge of thinking in this complex area. So we'd be delighted to take any questions in the couple of minutes which remain.
Thanks, Jeremy. I think just in the interests of time and helping people managing their calendars, we will wind up pretty quickly. But thank you so much for your presentation, Ray and Helen. Incredibly detailed, but also incredibly interesting. One question that did spring to mind from me was, in terms of systems and controls, in your experience, how robust do you think MGA systems and controls are at present? Do you feel like this might be an area that needs considerable scrutiny, or do you think on the whole, as I say, in your experience, MGAs are faring pretty well with this?
It's a really good question. Thanks, Julia. So I think it's probably fair to say that obviously general insurance is held to, as Helen has explained, a less exacting standard in many ways than other financial services sectors. So it's important that in answering that question, one takes a reasonable and proportionate approach in thinking about that. So I think it's fair to say that from an FCA perspective, when you look at enforcement notices and so forth, problems with anti-money laundering and anti-financial crime are not really a common theme within the insurance market. Putting to one side historic pieces around allegations made around the breaches of the Bribery Act, etc., which is slightly different, a sort of self-contained piece there. But generally speaking, they do not appear to be, it does not appear to be a severe issue in the insurance market based on publicly available material. So on that basis, I think it's reasonable to say that for the current threats and risks that MGAs face, it's probably reasonable to take the view that across the piece, their systems work okay. What this presentation is about, obviously, is are their current systems going to be ready for the future and the way that it could unfold and the risks that could be posed based on what came out of Uyghur Congress.
Lovely. That's great. Thank you for answering that so succinctly. And I hope I can assume that if our members wanted to start a conversation with Brown Jacobson on systems and controls and the wider issue, you'd be happy to engage on that basis.
Absolutely.
So if we've got contact details on the next slide, perhaps that's at the point that I can say, again, thank you so much to Helen and to yourself, Jeremy, and to you, Raymond. As I say, really fascinating topic and obviously very important to those that joined us today. Please do send your feedback onto the MGA when you receive the feedback link. We appreciate you, our delegates, for joining us today. We appreciate Brown Jacobson for talking to us about this incredibly important topic. The edited recording will be issued within the next 10 days. You'll receive a copy of the PowerPoint presentation, and just leaves me to say thank you again and have a great afternoon. Thank you very much.